All right, so I received a couple of motions a little while ago. Good morning, everybody, I'm sorry. And there are some things we need to talk about from yesterday. Are the jurors here? Okay, good. All right, so the order I'd like to do is, Mr. Jackson, yesterday you were going to take a look at any photographs you intend to put in with Dr. LaPosada?
Yes, those have been presented to the Commonwealth.
All right. Can I just, are you all in agreement, or are you just looking at them now, Mr. Brennan?
I haven't heard specifically from Mr. Brennan, but the issues that he had, obviously we're not, at this juncture, until we're referring, we're not going to bring in anything having to do with dog bites, claws, dogs in tissue, any of that information, but we are going to bring in exactly what we indicated yesterday. If there's an issue with, for instance, the ecchymosis, we've got a clean copy of the photograph without any of the narrative next to it, which is explanatory. The only one I think that does have narrative is the one with the Lucas machine, which Mr. Brennan indicated yesterday he did not have to do.
All right.
Position would probably agree.
So I need to know, just for instructions to the jury, about, I'm concerned about the photograph on page 5, figure 3.
The brainstem?
Yes.
Yeah, that's going to be, we intend to show that. That shows the...
So what I would like you to do, if you could, is just crop the center that shows what appears to be blood cells, or the red. I assume that that's the part you want to get into? Sure. If you can crop that, I'll let it in, and I still want to give an instruction, so I need to know what you're going to do with that. I was going to exclude it, but I understand. So if you can crop, yes, if you can do that, I think it takes away some of the sting on the gruesome photographs. All right, so you'll do just the brainstem on that, Mr. Jackson? All right. And so I'm concerned more about the ones that I think may cause the jurors some concern. So the photograph, figure 5, the Wisniewski spots, I thought that was in evidence. I don't know for sure if it's in evidence.
We went back and forth yesterday, and I don't believe that it's actually in evidence. It is not.
Okay, so
it's not in evidence. That was
okay.
Yesterday, we all assumed it was.
Yes.
I'll put it in evidence as.
All right, they've already seen it, so it's less likely to have an impact on them for purposes of the gruesome photographs. But and then on page 8, figure 6, the stomach lining.
Correct, that's already in evidence.
Okay, that's what I thought, Tori, you told me yesterday the number, right? So those are in. So are you using them again?
I'm going to use them again comparatively and probably side by side.
Okay. All right, I don't have a problem with that. Does the Commonwealth?
I don't.
Okay. All right. Those are the ones I was concerned of an instruction. If there's objections to hearsay or something, I'll give Mr. Brennan an opportunity to take a look at whatever he's got.
Understood.
Okay. All right. So with that, that's helpful. Thank you. So there is a new motion this morning suggesting that the Commonwealth open the door with their questioning of Dr. Russell to allow Dr. LaPosada to talk about bite wounds. So I've read that.
Correct. I'd like to be heard on that briefly.
Okay, sure.
Thank you. I'd like to start, if I may, by marking 2 documents for permission. One is Dr. LaPosada's entire report, and the second is
great.
her entire CD.
Okay. Yeah, those are the ones I needed from yesterday. So, yes. Yes.
Exhibits D, 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 and exhibits E, 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 E.
Okay. All right, go ahead, Mr. Jackson.
Thank you, Your Honor. We are asking the court to reconsider the court's ruling yesterday concerning Dr. LaPosada and her ability to opine on the issue of dog bites, dog bite and claw mark wounds and pattern recognition. We had some concerns yesterday and previous to yesterday about an issue that has been ongoing with the Commonwealth, and we've brought this to the court's attention. The Commonwealth has been using a tactic to shift the burden to the defense with cross-examination that's laced with indications or implications about witnesses that may or may not be called by the defense. That is a problem. I brought it to the court's attention at sidebar. The court will probably remember that colloquy. It was not an open court, but I expressed grave concerns, to use that phrase, that there was a burden-shifting system that was going on when Mr. Brennan is asking our witnesses about, or his witnesses, about other witnesses that may be on the defense witness list and may be called. Obviously, as the court knows, foundationally, we don't have to call anybody. We don't intend to call anybody. We don't have to call anybody, but we can call whoever we feel like. But we shouldn't be put in a position where our hand is forced to call witnesses because of questioning by the Commonwealth, which is improper. After I brought it to the court's attention, Mr. Brennan has continued along that same line. The Commonwealth has continued along that same line, and I want to bring something to the court's attention specifically. Last night, we pulled the tape. Dr. Russell was cross-examined by Mr. Brennan on the issue specifically of Dr. LaPosada and her opinions regarding dog bites. He asked questions over and over and over again. The colloquy probably lasted more than 5, 6, 7 minutes with Dr. Russell, specifically on the issue of whether or not she had seen Dr. LaPosada's reports, whether she was aware of Dr. LaPosada's opinions, implying that Dr. LaPosada had opinions about the dog bites. She was asked if she was familiar with Dr. LaPosada's credentials. Dr. Russell said, yes, she was familiar with Dr. LaPosada by name, that she thought she had impeccable credentials, and she very much wished she could have seen her reports as it relates to dog bites. It was an intellectual curiosity by Dr. Russell that was evoked and elicited by Mr. Brennan on cross-examination of Dr. Russell. She was then asked the seminal question: did the defense, Dr. Russell, give you any reports by Dr. LaPosada related to dog bites?
What page is that on here?
On the transcript?
Yes.
Oh, my motion's back at the desk.
Oh, I see it.
Does the court have it?
Yes.
Okay. I'll just read it. Question by Mr. Brennan to Dr. Russell. And so you think of all those forensic pathologists, medical examiners, you think that qualification and experience itself is not enough to qualify someone to give an opinion on a photograph about the genesis of a wound related to dog bites? Answer: well, if a forensic pathologist autopsied 1 or 2 cases of dog bite wounds versus my experience with over 500 to 1,000 cases of dog bite wounds, I'm not sure that person would be a very good expert in that kind of case. Question by Mr. Brennan: have you ever heard of a doctor named LaPosada?
So are you going to read all 3 pages?
No.
So I've read it, Mr. Jackson.
I'd like to read it into the record, Your Honor.
It's in the record. I will put this transcript into the record. I'm not going to let you read 3 pages here.
It's not 3 pages, Your Honor. It's about another 5 lines.
The
It just
part
goes to
that
the
you
top of the
brought
next
to
page.
my attention is on page 15, not where you're reading.
The colloquy between between Dr. Russell and Mr. Brennan was specific to dog bite wounds. It was specific to Dr. Russell's understanding of whether or not Dr. LaPosada had been retained by the defense, whether she was a defense expert, whether she had written a report, and whether she opined about dog bites and dog bite wounds. And after she was asked if she had been provided any reports by the defense attorneys specifically, from Dr. LaPosada related to dog bite wounds, Dr. Russell said, no, I haven't been. And to summarize her statements, which the court has in front of it, Dr. Russell went on and said,
I really wanted to see what Dr. La Posada had to say about these dog bite wounds. I really wanted to read her report. But no, I was never provided her report or reports by the defense. And of course, Your Honor, as the court knows, that is standard operating procedure. I don't trade reports between and among experts because obviously I want independent analysis. I don't want to cross-contaminate any opinions, et cetera, and be accused of doing so. So of course we didn't provide a report from Dr. La Posada to Dr. Russell. But Dr. Russell's intellectual curiosity was then extracted from the witness stand, and the jurors heard all of that. So then days later, not weeks, not months, 3 days later, after eliciting testimony from Dr. Russell about Dr. La Posada having a report, being hired by the defense on the issue of dog bites, and not providing that report to Dr. Russell, the Commonwealth then moves to exclude the very testimony that he was eliciting from Dr. Russell, leaving the jurors with a very, very deep and irremediable misimpression. They used it tactically as a sword and a shield, and that's burden shifting. That leaves the jury with the impression that Dr. La Posada was consulted by the defense, number one, that she wrote a report, number two, that the report was about dog bites, number three, that she didn't provide that report to other experts, number four, and the reason she didn't, obviously, is because her opinion, Dr. La Posada's opinion, would be harmful to the defense. That's the only reasonable interpretation of those facts. And the Commonwealth has taken advantage of that. The Commonwealth's questioning of Dr. Russell about Dr. La Posada and her report and her opinions about dog bite wounds specifically was deliberate, and it left the jury with an open question. We know they consulted her. We know it was about dog bites. This is how the jurors are thinking about it now. We know they consulted her. We know it was about dog bites. They hid the report from Dr. Russell because they didn't want her to know about it. Ergo, must be harmful to the defense. Now we've got Dr. La Posada on the stand. Her credentials are peerless, absolutely peerless. They've got possibly the most qualified medical examiner in the country, certainly on the Eastern Seaboard, right in front of them, about 6 feet away, and the defense is not going to ask a single question about her opinions concerning dog bites when she reviewed the entire autopsy. How is the jury going to conceive that? How is that going to land with them? The answer is they're going to think, they have no choice but to think, the only reasonable explanation is, if Dr. La Posada's opinion helped the defense, they would ask her. If they don't ask her, it's because whatever Dr. La Posada says about that right arm and those wounds, it's got to be harmful to the defense. They would absolutely ask the question. So the Commonwealth got to have it both ways. They got to ask Dr. Russell about Dr. La Posada and imply that Dr. La Posada had opinions about dog bite wounds. And then they have it the other way, which is, let's ask the court if she will exclude Dr. La Posada from testifying about the very issue that they brought up in front of Dr. Russell. That cannot stand. That ensures, it reasonably ensures that the jury will misrepresent or misunderstand the import of why we're not asking Dr. La Posada about her expert opinion, especially as it specifically pertains to dog bite wounds. I want to talk for just a second, and that has, by the way, that has constitutional implications. Ms. Reed is entitled to a fair trial, not a fair trial that the Commonwealth designs, not a fair trial that the Commonwealth curates, but a fair trial. Regarding Dr. La Posada's credentials, we went back through, specific to the court's questions yesterday, her resume. There are no fewer than 13 classes, 13, that she has taught specific to wound pattern recognition that have included dog bite recognition. On page 7, she was the course director for medical legal death investigation. That was in 2013. She taught about dog bite recognition in that case, or in that course. She was a thesis advisor for Master of Science Graduate Medical School, Boston University School of Medicine. Taught about dog bites. Staying with page 7. Forensic Pathology Course Director in Pathology. Course 205. Taught about dog bites. Member of Quality Assurance Committee, Training Division of Trauma and Surgical Critical Care, teaching on the issue of wound recognition, animal bites, and specific to dog bites. Pediatric Forensic Pathology, Texas Homicide Symposium. She was a presenter in 1989. She taught about the issue of dog bites as it relates to pediatrics, children, dog bites in children. Forensic aspects of physical child abuse as related to being left with dogs that can injure a child, dog bites, dog bite recognition. These are all classes taught by Dr. La Posada on the issue of dog bites to other medical professionals. The one that stands out, however, and I'm not going to go through the other 9 or 10 or 11, the one that stands out is 2015 and 2016, 2 courses. The name of the course, Emergency Room Forensics, Evidence and Patterned Injuries, New England chapter of the International Association of Forensic Nurses, taught in Norwood, Massachusetts, both times, specific to dog bites and the issue of dog bites as seen by emergency room physicians, how they should handle them, what they should do with them, how they should view them, what to look for in terms of pattern recognition. She's eminently qualified. I will leave the court with one thought. The court indicated when qualifying Dr. Russell, one of the preeminent things that the court mentioned in qualifying Dr. Russell is that Dr. Russell utilized a methodology that the court sanctioned and quoted and said the methodology that she used of wound pattern recognition, dealing with differential diagnosis, utilizing and interpreting dog bites by the method of exactly what Dr. Russell did. Differential diagnosis is something that the court said was exactly why the court sanctioned Dr. Russell and blessed Dr. Russell as a qualified expert, and that's exactly what Dr. La Posada testified yesterday she utilized and utilizes in coming to her opinions and conclusions. Going back to the open door issue, obviously she's eminently qualified, but, Your Honor, this cannot stand. The Commonwealth cannot have it both ways. They cannot walk up and say and leave the impression with the jurors that Dr. La Posada opined about the dog wounds, but we're not able to hear it. We, the jurors, are not able to hear it because obviously that is something that is her opinion, whatever it might be, is harmful to the defense. When in truth and in fact, it's exactly the opposite. Dr. La Posada's opinion has never wavered. Those injuries on John O'Keefe's arm are from a dog, period, full stop. Anything less than presenting that to the jury at this point would be to perpetrate an intentional fraud on this jury. Ms. Reed is entitled to more. She's entitled to better. She's entitled to the evidence.
All right. Thank you. Mr. Brennan?
The pattern of conduct that stands out is persistent, repetitive, contrary to court rulings and court orders, and deliberate. And that is the defense uses their witnesses to vouch for their own credibility. They use their witnesses to introduce information they know is not admissible, and they use their witnesses to introduce otherwise inadmissible hearsay. Dr. Russell took the stand, and she was led into answers where she was vouching for her own credibility. Dr. Russell promoted herself not only as an expert, but through the defense's questions as virtually the only expert in America who has the expertise to give this type of opinion. It is the defendant's tactics that open these doors that they then want closed. The defense had Dr. Russell all but assure the jury that she uniquely was in the position to give any type of opinion regarding dog bites. Inevitably, when I asked Dr. Russell, and I began asking her about her credentials, whether she thought that she was exclusive, and I mentioned Dr. La Posada, she denied ever reading anything about Dr. La Posada. I did not specify whether she read an opinion about a dog bite. I asked if she had heard about Dr. La Posada. She denied it, and then she told us that she knew about Dr. Sheridan. Unsolicited, then added that Dr. Sheridan, involved in a previous proceeding, believed that the bites were consistent with dog bites. I don't know how she became aware of Dr. Sheridan's testimony, and since the defense doesn't speak to her about these things, she must have watched it on her own. But inevitably, she introduced inadmissible hearsay and inadmissible opinions. And so the sum zero here is that Dr. Russell has denied that she saw anything relative to Dr. La Posada, ensured that she was exclusively qualified, and introduced an improper opinion. As it pertains to dog bites. We asked her questions about her specific experience. She did not provide a basis, and so her opinions regarding dog bites should not be permitted in this trial.
Throughout the record, two things stand out about that speech. Mr. Brennan literally just said, I didn't elicit any information about dog bites. I just asked about her experience. Question by Mr. Brennan.
That's not what I said. That is
Excuse me.
No, I'm not going to.
So
That's not what I said.
I heard what Mr. Brennan said. You don't need to tell me what Mr. Brennan said, but go ahead to
How
your
about
argument.
if I quote his words? How about that? Question. And so you think of all those forensic pathologists, medical examiners, and you think qualification and experience itself is not enough to qualify somebody to give an opinion on a photograph about the genesis of a wound related to dog bites. The question was specific to dog bites. That's how he introduced the subject matter to Dr. Russell. Then his next question was, have you ever heard of a doctor named Dr. La Posada? Those were his words. Then he goes on, I think he also just said that he did not elicit information about other individuals, including Dr. Sheridan or anybody else. Question by Mr. Brennan. Were you ever told what other people's opinions might be regarding those photographs? That's the question that she was answering when she said, quote, I'm aware that there was a Dr. Sheridan involved in a previous proceeding, and he believed that those were consistent with dog bites. That was in relation or in response to Mr. Brennan's specific question. She didn't just elicit that. She didn't volunteer it. She said it because he asked her. And that was all by design. The entire thing has been by design. He elicited the information suggesting that Dr. La Posada was being hidden from Dr. Russell because her opinion would harm the defense. He left that with her on purpose, then turned around and 3 days later said, and by the way, the defense should be disallowed from using Dr. La Posada to talk about the very dog bite wounds that I asked Dr. Russell about. That cannot stand in this courtroom.
Go ahead.
It's helpful if you read the entire thing in context, which I won't do. We always have a right to object to an inadmissible opinion. So the suggestion that somehow an ambush here is not only misplaced, it's strategic by the defense to try to create an error. It's improper.
All right. I'll be out in 10 minutes on this, and we'll get started right away with Dr. La Posada.
All right, the court, please.
So I'm not going to allow Dr. La Posada to testify regarding dog bites. Your rights are saved. I'm going to give an instruction regarding burden shifting. So
I just think it's outrageous. I think the conduct is outrageous. And I don't think that a pure instruction can do anything except bring the point home again.
okay.
But if the court is not willing to allow her to testify to her full opinion to immediately be assigned to the service, can she at least testify that she reviewed the arm, looked at the arm, and it's consistent with an animal? Can we at least split the baby?
I will do that. I'll allow that. Yes. Over the Commonwealth's objection.
Then I look to have the cross-examiner, because if you're going to allow a consistent opinion with a dog,
No, Mr. Jackson said animal.
I'll leave it at animal if that's what I can get. I'll take what I can get.
In her experience, Mr. Jackson, you have to lay a foundation. In her experience, seeing animal bites, this is consistent with what she has seen in an animal bite.
And that will include, I'll come to sidebar before I display anything, that will include a representation of what an animal jaw looks like.
No. No, it will not.
Why is that?
That's my ruling, Mr. Jackson.
So no visuals.
No visuals, just that one sentence that's consistent with what she has seen is an animal bite. A brief foundation, because I'm letting that statement in as long as she has said, as long as she testifies that she has seen animal bites over the years. That's it, Mr. Brennan. That's what I'm doing. So you don't want an instruction, Mr. Jackson? Okay. All right. So there are two other quick matters, but the jury's been here, and I don't think we'll get past the break without this anyway. I may have left it in the... I left it in my office anyway. So let's just bring the jurors in and move forward with this. All right, Paul, I'm just going to take...